to transparency. Hello, everyone. Welcome to this webinar, Inaccessible Information, Australia's Approach to Transparency. I'm Quentin Dempster, a has-been journalist. This webinar is presented under the auspices of the Centre for Public Integrity, a not-for-profit think tank. Public integrity, how woke is that? After our American friends elected Donald Trump as their next president, I feel we're all pushing mad uphill. But you'll all be pleased to know the Centre for Public Integrity remains undeterred. Join us to confront the transparency question of four great Australians and experts in this field. Please welcome Rex Patrick. Rex is the Director of Transparency Warrior. He's a former South Australian Senator, now a relentless freedom of information litigator, litigation which has gone in some cases all the way up to the full federal court. Rex is standing again for a Senate seat in South Australia under the Jackie Lambie network. Hope you get there, Rex. We need you in there. Rex has filed nearly 700 FOI requests across both Liberal and Labor governments, and his cases have met with some setbacks and some significant success, establishing precedents, particularly in relation to national cabinet documents. And you'll remember his success in what became known as the shredder case. Ministers can no longer shred documents on leaving office. The shredding companies are in outrage. Hello, Rex.
G'day, Quentin. Thank you very much for inviting me along. And
please welcome Emeritus Professor Peter Coaldrake. Peter's been head of the Queensland Public Service after the Fitzgerald inquiry in the late 1980s exposed institutionalised corruption in that state. He then became Vice Chancellor of QUT, the Queensland University of Technology. You can Google his extensive and distinguished CV in many public academic, arts and regulatory roles, including the tertiary university sector. But specifically, we've asked Peter to join us today because of his recently published report, Let the Sunshine In, with its sweeping recommendations to make what we all cynically called open, accountable government, in fact, a practical reality through the digital revolution, enabling the limitless and cost-effective storage capacity of cyberspace. Welcome, Peter.
Thanks very much, Quentin. Nice to be here with everyone.
Maria Nawaz is General Counsel at Grata Fund, Australia's first not-for-profit litigation funder and incubator. Maria leads Grata's legal work in climate justice, human rights and democracy, with particular focus on FOI. Hello, Maria.
Hi, it's great to be here, Quentin.
Dr. Catherine Williams is Executive Director at the Centre for Public Integrity, leading the Centre's efforts to secure greater transparency of government information and better access for all citizens and their representatives within the parliaments of our mighty nation. Welcome, Catherine.
Thanks very much, Quentin.
Rex, to you first. You've established there is no willing acceptance by government of the conceptual basis of freedom of information laws and regulations. Have freedom of information laws now been discredited, in your view?
Well, I'll just start off by saying that transparency is a word that is only shouted from opposition benches. We see, we saw going into government a set of promises about things like whistleblower protections, integrity, and transparency, and in particular FOI, that simply haven't been implemented. And I run FOI training courses, and I sometimes turn up to Liberal offices to train staffers, and I'll get a comment from one of my old sort of Liberal colleagues saying, "Oh, Rex, you won't believe how secret this government is." So they've found themselves in opposition and then frustrated by a lack of transparency, not understanding that they were basically the same. Our FOI laws do have some areas where there could be improvements, but I actually don't think the laws in themselves are necessarily broken. What's actually broken is the culture from the very top that simply resists transparency. There's a great judgment by Justice Kirby in a case called Osland, where he describes the history of secrecy in government and the revolution that was the FOI Act in 1982. And unfortunately, with hundreds of years of tradition of secrecy prior to that point, it's taken some considerable time to try and get the executive to appreciate that In actual fact, transparency helps with democracy.
Peter Coaldrake, that's what you found, wasn't it, when Anastasia Palaszczuk, the Premier of Queensland, got you to look at the culture of a government which had been in place for a long time and arguably atrophied. But what did you find about what Rex says is the overarching culture?
Well, I obviously agree with that, and tone from the top was really the central theme of my report. As we probably all know, Queensland was, and you experienced, Quentin, Queensland was pretty slow off the mark in terms of public sector reform. It had always regarded it as not a material matter, but was forced by crises, first in the 80s when the government split, the coalition government at the time split over the most modest reform suggestion for a Public Accounts Committee. And that, of course, led into the Fitzgerald inquiry. So our Queensland was slow. It really came at the matters very fast. But over the years, there's probably been some burnout associated with reform. The particular prompting for my report was in part because a couple of integrity officers, as it were in spats either with one another or with ministers and government. And I think the Premier at the time, and to her credit, asked for the review to be done. She may not have expected me to have gone as I did, but it wouldn't have been much surprise because the issues were pretty obvious. Tone at the top, and I use the term carefully, quite a lot of fear in the government, quite a lot of fear in the public service, which is a very unhealthy thing. If you're on the side of transparency, then a fearful environment is not going to be a good idea. With regard to the particular recommendations, I think you were tempting me to say something about whether the new government was committed. In opposition, and goes to Rex's point, oppositions inevitably will support reform suggestions like this. The early signs, I think, are more positive than otherwise in terms of the appointments of in terms of the appointment of directors general for terms that are outside the electoral cycle, and so on and so forth. But the real test of these sorts of reviews is not whether governments implement particular recommendations, but whether they recommend the spirit of the report. And that's leadership at the top. But yes, let's just deal with the litigation which has been provoked by what we see as the deficiencies of transparency or FOI. Maria, the Grata Fund is a litigator. There's a lot of work for lawyers in this, and I don't know about our audience, but although I love lawyers, they're very expensive. What successes and failures have you had in the litigation that you've funded?
Thanks, Quentin. So picking up on what Rex has said is we know there's a culture of non-disclosure in our FOI system, and we found that litigation is often necessary as a stick to force compliance with the FOI Act. So we funded a number of cases. I'm going to talk about three briefly. So one was Justin Warren's case on robo-debt documents. So he sought documents on the robo-debt scheme that had the potential to reveal what ministers such as ScoMo knew when the scheme was set up, and his request was initially denied on the basis that the documents were prepared for Cabinet. The Information Commissioner then reversed this decision, but Services Australia appealed to the AAT at the time and were successful. Warren then had to appeal to the Federal Court and then to the full Federal Court, where he finally won, and the court found that the Cabinet exemption should be interpreted narrowly. So we often need the court to interpret how the law should apply because decision makers at the lower levels aren't doing it correctly. We've also supported Rex's case on the ministerial reshuffle loophole. So the case challenged the idea that documents held by ministers who resigned or are reshuffle cease to exist and are then no longer subject to FOI law. So this is really absurd. Rex challenged this successfully at both the federal court, and then the AG didn't like this decision, appealed, and Rex again won at the full federal court, closing this loophole and setting a huge precedent. And then the third case I wanted to talk about was unfortunately unsuccessful, but still a really important case, which is Rex's case on unreasonable delay at the Information Commissioner. So the Information Commissioner is causing delays of about 1 to 3 years in its reviews on agency decisions on FOI requests, which means when the information finally is disclosed, it's sometimes no longer politically relevant. So Rex challenged what he calls unreasonable delay in both the federal court, which was unsuccessful, appealed to the full federal court, which was unfortunately unsuccessful, and was just last week denied special leave to have the case heard at the High Court, which leaves that issue unresolved through litigation and shows why we need a two-pronged approach, not only litigation to force government to do the right thing when it comes to transparency, but we also need law reform where there's issues that we can't address successfully through litigation.
Thanks, Maria. Thanks, Maria. Rex, tell us why you get so much pushback on all these FOI applications. When I said at the start, with the limitless storage capacity of cyberspace, there should be a default of material going up on the public record. And I'll get to Peter's wonderful recommendation for Queensland later. But why isn't there that immediate template of getting material up?
Okay, I'll answer that. I'll just go back to Maria's point, however, just to let you know, I was unsuccessful in the High Court, but my appeal option now is to become a senator again. So to do some of that law reform. Now, one of the things that would help the FOI Act would be a time limit around the Information Commissioner that has been talked about. That might otherwise give you a free right to go to the next level. But in terms of the sorts of things that happen, and this comes to the culture that everyone has talked about thus far. There's a culture from the very top. You know, if something gets out and it's a bit politically sensitive, there's going to be pressure all the way down. And indeed, in proceedings, someone under oath, a senior official under oath, had advised the AAT that they had received instructions from the minister's office, to do things like not put information on the record because it might get FOI'd, which is just to me is improper. But because of the culture at the top, it filters all the way down to someone who's a sort of a middle-ranking official who has to make a decision, and they look and they say, geez, this is going to be sensitive, or this may cause us more difficulty in progressing a matter. And I don't get paid enough to make these sorts of decisions. So it's quite easy to just say no, because Rex has always got an appeal right, or Mr. Smith's always got an appeal right, or Mrs. Boyle's got an appeal right. Without understanding that one of the key enemies of FOI is delay. You know, if you want to be able to participate in democracy, which is the very essence of why we have our FOI laws, then you need to have access to contemporary information. And with the delays we see at the moment, so if we have an FOI officer makes a decision and says you can't have something, that then pushes it to the next level where there might be 3 years delay.
Right. Catherine, I want to come to you, because what we seem to be confronting is the bureaucrats' view and the ministerial view of cabinet secrecy. That if anything, submissions, decisions, they get up to cabinet, they're cabinet in confidence. Now, the Centre for Public Integrity has a bit of a problem with this. What have you found as you researched the impediments to transparency?
You're right, Quentin, we do have a problem with it. And so when we're talking about this culture of non-disclosure that all my colleagues here today are speaking about, we see this problem not just in relation to disclosure to the public of information, but also in respect of the disclosure of information to the Parliament. And we know in our system of government, one of the most powerful tools for the Parliament to hold the executive to account, which is its responsibility, is the use of upper house orders for production. And unfortunately, increasingly, governments take the attitude that upper houses make an order for production of a document, and the government goes, yeah, well, we're not going to comply with that. In fact, what our study of the statistics involved shows is that since 1993, rates of compliance have been gradually decreasing. Now, we're still running the statistics around the numbers around this year, but it looks like compliance might have lifted slightly on the previous year, but is still nowhere near what it should be. And making up a significant portion, around this year, it seems around 50% of refusals to comply with an upper house order for production is a claim of public interest immunity, in other circumstances also called Crown privilege or executive privilege. And of course, there are going to be cases where public interest immunity is validly claimed. We would all accept that there are going to be valid cases of national security.
Give us an example of
a valid claim. That's a good question. A valid claim that something relates to national security, or a valid claim that something relates to cabinet deliberations, separate from cabinet documents, of course. So it is accepted that some information is going to need to be kept secret in the public interest so that ministers and senior officials can make the sorts of decisions that they need to make in order to govern. But the problem is that there is no way to determine the validity of these claims of public interest immunity. The executive gets to make them, and nobody looks at them to say whether or not they're valid claims, which is where things get really tricky. And at the federal level, that is, there's no model. In New South Wales, there is a model in place. There has been for a long time, where the New South Wales upper house has an independent legal arbiter. And if there is a claim of privilege made by the government in response to an order for production by the Legislative Council, and the council contests the validity of that claim, an independent legal arbiter can look at it and say to the upper house whether it is a valid claim or not. And the system works. And it seems to be a cultural thing in New South Wales that this mechanism works, because interestingly, exactly the same mechanism exists in Victoria, but it doesn't work. And it has never worked because in Victoria, no government has ever provided to the clerk a disputed document so that an independent legal arbiter can be given the document and this dispute mechanism can begin its process. So we know that we want to see at the federal level and in other jurisdictions around the country this sort of mechanism that exists in New South Wales, but there needs to be built around it the culture that's required for it to actually function properly.
I think we've established consensus on that point. Peter, can you comment on FOI from your Queensland experience as a mechanism to enforce transparency from a very reluctant executive government sector?
I think that the theme that's already been set out applies in Queensland. I don't think there's any material difference in character. The forces of resistance and caution and fear in Queensland, that's called the courier mail test. How's it going to look in the courier mail? It really goes back to, I guess, to how public servants themselves see their role. And when I did my review, one of the things that quite shocked me, I spoke to most of the ministers at the outset, and I would ask an ice-breaking question, how's it going? What are your priorities? And sort of ask them to talk a bit about the role of the public service. And one minister, quite a senior minister, shocked me by saying, I've never received a recommendation from the public service I didn't agree with. And I said, you don't think there might be a problem there? Which really went to what the role of the public service was assumed to be, that of the ministerial officers. And like in other jurisdictions, the role of the public service has been weakened and weakened over a couple of generations. In a sense, I have this romanticised view that we need to rebuild the capacity of the public sector, because government tends to either throw things to commissions of inquiry or out to consultants far, far too often at great cost to the public. and that's become a really big issue and overlaid in all jurisdictions, including here.
That's a good point, because if you want to get cultural change for transparency, the appointment of agency CEOs or departmental heads, where their heads can be cut off by the minister if they don't want them. And you recommend, Peter, that there be changes to that with fixed 5-year terms.
And that
just take us through that, your thinking there.
Well, I just thought, self-evidently, if you're seeking to have a professional public sector at the most senior levels in particular, it's important that appointments, as far as you can, be removed away from the electoral cycle. And to give credit to the new government, I understand some of the DG appointments, I haven't checked all of them, that the DG appointments at least look as though they're being made for 5 years, which is a very good start. I do wish to acknowledge both Anastasia Palaszczuk recognising that some of this had to be done, though I think her government was a bit constipated in how to respond. On the cabinet release matter, which was referred to briefly, I recommended.
Let me just remind people that Coaldrake recommended that cabinet papers submissions, the basis of the cabinet decisions, be publicly released within 30 days of the decision, not archived for 30 years.
Yes, that's right. And that's right. And people thought I might have taken a leave in my senses, but in actual fact, this is what's been going on in New Zealand. I guess the relevance, though, of the New Zealand case is that across party lines, to a greater or lesser degree, they've been reforming and opening up their government for 30 years. I think what was hard to digest in Queensland was a recommendation which goes effectively from 30 years to 30 days. I got one rather sheepish phone call from a senior DG a number of months before the government actually bit the bullet on it, saying, how do you think we'd go? What sort of reaction do you think there'd be if we got to 40 days? I said, listen, 40 days is a damn big improvement on 30 years. And I think people would regard it as quite a sensible step. So the implementation of that, if it actually flows through, will be very good. The issue to always watch for will be the carve-outs. What matters are the exceptions, and the exceptions can quickly become the rules. And once again, you go back to tone at the top. If the top leadership is saying, let the stuff out, it's much, it's going to be much better in the long haul. Then you're in actually a good space. If there's a resistance and defensiveness from the top at the outset, you're going to be in a world of pain.
Rex, the revered current Prime Minister Anthony Albanese must hate you after you forced the publication of all his diaries. What about Peter's suggestion of, number one, the change of public service culture by reinvesting frank and fearless advice through their executive contract structure, so the minister can't get rid of them on a whim for no reason whatsoever?
Look, I do think there needs to be security of tenure in respect of public servants, but just in relation to frank and fearless advice. And I'm fresh from 2 days of argument in the new Administrative Review Tribunal in relation to documents that are said to be deliberative in nature, which can be overcome by public interest. And I have to say that the last 3 times I've been in the ART, I've been confronted by a claim by public servants that if this information is released, it will cause a chilling of our frank and fearless advice or candor. Now, of course, that's not really fearless advice if you only want one person to see it, but that being the minister. But in that case, it's quite interesting. There's been many sort of judicial views about this idea that if you force public servants to disclose some of the conversations that might take place, it will in fact cause them to not, perhaps represent the public as well as what they should otherwise have. And in the last 3 instances, I've actually adopted a new argument, which I'm trying to get around all of the varying opinions about this factor, and that is to use to draw back to the statutes. So an example would be that in Regulation 7 of the Public Service Regulations, officials must always keep information confidential, but to then extend from that, there's abilities in that same regulation for authorised release of information, and that includes in accordance with law, which might be in accordance with FOI or for subpoenas, or a requirement for an Auditor General to get access to information, or the requirement for the Parliament to get access to information. So it's a little bit sort of fake to suggest that just because you do an FOI, it's going to chill the advice, when in all circumstances, there's a whole range of reasons why documents ought to be disclosed. And actually, most officials are not qualified to work that out. The statutes, so Section 10 of the Public Service Act, says actually quite explicitly that public servants must act with integrity. They must be professional. They must be open and accountable to the Australian public, and they must give fulsome, evidence-based, impartial advice. So actually, so I now challenge, and I've been very successful in this, challenging these claims about it's going to reduce our candour, to say the statutes don't permit that. If indeed a public servant backs off on their advice, they in fact commit a malfeasance. They're actually in breach of their public service obligations. They just need to do the best possible job in a meeting, and disclosure is someone else's problem. And actually, I've been very successful with that. Unfortunately, I've just got a few decisions around that now. It's probably one where I need to lose and get it up to a judicial level to argue that particular point. But that's something I confront all the time, where they say we can't release this information because it will cause all of our public servants to be shrinking violets, and in law they're not allowed to be.
I appreciate that, but what you've just said frightens me, particularly in the context of Trump in the United States, where all the reporting coming out of there that his new cabinet and his administrators are to be appointed are going to be unassailable loyalists to him, not to the processes or the frank and fearless exchanges that should go on within a robust bureaucracy. Catherine, is there a danger here that the forces of transparency can overreach, and we will drive a sort of a Trumpist change to the public sector in Australia?
Look, no, Quentin, I don't think that that's the case. I think the danger here is for governments to go on, as they have been going on for some time now, behaving in a way that, in my view, is really contemptuous of the public, contemptuous of upper houses of parliaments, treating information as though it belongs to them and relates to them rather than belonging to the public. I think that executives need to get their heads around that they are not governing kind of against the public, they are governing for the public, and the public has a right, and it is a right to information. And one of the best things that they can do to protect the public trust in our democracy, upon which our system depends, is to be transparent, so that people can see how decisions are being made and be able to have trust in that process.
What about Peter Coaldrake's idea of a default template of documents at cabinet level being published on the web within 30 days? Would that help us change?
That would make a hugely significant difference. We'd love to see that adopted by governments around the country. We'd challenge them to take that approach, do what New Zealand is doing. What is there to be scared of? Of course, there are going to be cases where there are valid claims to exempt documents from disclosure. Of course, that won't change. But the default position does need to be disclosure.
Maria, that would put the Grata funds requiring all its funding to go elsewhere, not litigate if we got that breakthrough. Would you support such a breakthrough?
Yeah, we'd love such a breakthrough, Quentin. You know, one of the major issues we see in FOI are documents not being disclosed because of the cabinet exemption and that being interpreted far too broadly. But I think there'd still be a lot of FOI litigation for us to continue to fund because a lot of documents are not cabinet documents and they're still being denied as well. So I think we'd still need to do the work, unfortunately. It wouldn't solve everything.
I have a saying on my website, Quentin, that says that I hope the government puts me out of business by being transparent.
That's a wonderful, that's a wonderful thought. Peter, is the new Premier Crisafulli going to proceed with the 30-day exposure of cabinet level submissions?
I assume so, yes, I assume so. The decision was only made relatively late in the previous government's term. So I don't, well, I'm assuming that, as I said before, the matter to watch will be exceptions or carve-outs. I just want to go back to a broader matter, really, relating to the role of the public service. There is a fear oftentimes, it's not just a career male fear in the career male test fear in Queensland, that ministers are worried about matters coming out because they might be seen to have gone against the advice of the public service. Well, the role of a minister is to sift advice and form their own views. They should get the impartial, brave advice, if you like, sometimes from the public service. They'll get their political advice out of their own heads and out of their ministerial staff. Governments, depending on their persuasion, will understandably have lobby groups or seeking to influence, and that's a legitimate part of the democratic process. But there's a fear. There can easily be a fear by ministers too that they can't step out of line, and I think that just cascades down into the public service. So you get almost dictation being provided from the very top, and people just following that herd.
Yeah, that's a problem. Whistleblower protection has been considered. Now, there are a lot of whistleblowers who may be watching this webinar, and everybody's concerned about Boyle and McBride. One's in the slammer, one's going through the torturous process of court proceedings. And there's been a move for a whistleblower protection authority. Do we really need, after we've had whistleblower protection arguably on the statute books of the state, federal and territory jurisdictions, do we really need another agency to hold the hand of people who've got the courage to come forward and say, hey, there's something wrong here. There's malfeasance or corruption or there's misspending or what have you. There's waste of public money. Do we really need a whistleblower protection authority? Rex?
Look, I think it is necessary. We must sort of couple that with the idea that our whistleblower laws are broken. The case of Richard Boyle, he lost his full court appeal in the Supreme Court in South Australia. It wasn't a loss in the context of saying that in some sense he was wrong. The loss was that the full court affirmed that the law is broken. In his particular case, what had happened was, and this is why a whistleblower protection authority would be helpful, in his situation, the full court found he was a whistleblower. The full court found that when he blew the whistle, the ATO botched the investigation. There's no question about his motive in the court's ruling. The problem with Richard, and we've got to be careful with what we say here, is that there are allegations that he broke the law in the process up to the point where he actually blew the whistle. And the question before the Supreme Court was, in effect, it says that the law says that people who make a public interest disclosure are protected. What's the meaning of the word make? And is it a big verb, meaning you prepare all of the material. You might want to take some material home so you don't have to prepare your public interest disclosure in the view of your boss. Now, you might break the law in doing that. You might be taking government documents home to legitimately put them beside your computer to prepare your disclosure. Is that part of the making of a public interest disclosure, or is it a small verb that just means at the point at which you hand it over, where you make the public interest disclosure? And the full court ruled that it was a small verb, and that's part of the problem. And we've used a number of senior counsel and a number of judges to work this out. And so you shouldn't have to be a senior counsel or a King's counsel or a judge to be able to blow the whistle. But that's the situation that Richard's found himself in that he and it's taken a full court decision to work out what is the protection, and that's where a whistleblower protection authority would be really good. I'm someone who's blown the whistle. I was protected because I worked for a parliamentarian, and the Prime Minister was really angry about what had happened. That was to do with security breaches by the French submarine manufacturer, and the Prime Minister, I remember Christopher Pyne, was really angry, but I was protected because Nick Xenophon was the only person who could fire me. But
that's parliamentary privilege, that protection.
Well, no, it wasn't. It was just, I blew the whistle, and normally if you're on the inside and you blow the whistle, you can get pushed out for all sorts of reasons that might not necessarily be attributed to the fact you blew the whistle. In my case, I had a senator who, so in some sense, I was what's called a bell ringer. I was on the outside blowing the whistle. But the point that I wish to make about that is that most whistleblowers, very brave people that they are, they're generally people who are not status quo people in the office. So sometimes there's always a bit of sort of a view that they're troublemakers, but they blow the whistle. And you know what? I reckon if you asked Richard Boyle about how he might blow the whistle a second time, he'd take a completely different approach. And you can just about ask every whistleblower that question. And that's the point. Everyone starts and blows the whistle once, and that's it. And they're not experienced at it. And that's where you need something like a whistleblower protection authority, where you can go to and say, this is the issue. How do I do this properly? How do I not get myself into trouble? And then just to come back to say, was the court unreasonable? Well, if I pick up documents and unlawfully take them home to prepare my public interest disclosure, you might say, well, that's pretty reasonable. Why would you get in trouble for that? But technically, I may be breaking the law. What if I broke into my boss's house when he wasn't there to get documents to show that that there was some sort of corruption in the office? And that's the problem the court has, is to say, well, if we say that you're immune when you're making, in the big verb sense, when you're making the public interest disclosure, what does that allow people to do? And so we need in that particular case, you might need a law that says, if you were reasonable in the preparing of your public interest disclosure, there's an immunity. And then it might come down to what a judge thinks was a reasonable action to take, even if you did break the law along the way. So it's complicated.
It is. Catherine, your comments on that whistleblower as well, but we're back to transparency and the overarching culture and the case law that is now well established in Australia. Where should this go on people making disclosures? I always thought myself that having dealt with some whistleblowers, that an anonymous methodology would be better for their own protection. Their careers, their lives can be shattered by putting their hands up, however brave they are.
You're right, of course, Quentin, that the consequences that whistleblowers can experience for taking decisions that are particularly courageous ones at times and very much in the public interest, those consequences can be devastating. And what Rex talks about the navigability of the system is why the centre has for a long time been a strong supporter of there being an independent whistleblower protection authority in place to support people, because what we have to see is a system that encourages people to come forward and make these disclosures in the public interest. We don't want to see a chilling effect upon people's preparedness to do those sorts of things, which, I mean, in a sense, if you look at what's happened to whistleblowers in this country, you'd have to say, well, a rational person would have to think twice about whether they were prepared to go ahead and blow the whistle, given the state of the current regime and the state of the case law. You'd have to be thinking twice about it, which is why we really need some clear indication from the Parliament via the institution of an independent protection authority to show that actually we want to make the regime able to be easily navigated by people who want to make public interest disclosures, and that they should be supported by the system to do so.
Maria?
Yes, I completely agree with that analysis. I think what we've seen with Boyle and McBride is a failure of our democracy, in that we've got inadequate whistleblowing laws, and we've seen these high-profile whistleblowers suffering from really serious reprisals from blowing the whistle. So I agree that we definitely need that independent protection authority to assist people to blow the whistle in a way that doesn't lead to them ending up in jail, for example. It's too high a price for most people to pay to even to be able to consider to do that, if that's a likely outcome.
Peter Coaldrake, you've been Vice-Chancellor of QUT, and you've been subjected to FOI applications which might have, if you've revealed, might have been contentious for that entity. What was your experience when you were running QUT?
Our general approach, Quentin, was to basically let the stuff out. There were always arguments about it, but I think that I think we had a lessening of FOI type activity over the years, mainly because we tried, I think, at all levels of the organisation, from the governing body down, to make information available, and I'm sure we never got it right all the time, but it was very important not to have a punitive culture, for people to understand that they could operate in that environment. Universities are interesting cases in point, because the academics will tend to read what they want to read and read nothing else. And in fact, if you want to get through to academics, the best thing to do is to write a circular saying salary increase, or I'm not being entirely trite, but I thought that there were very few consequences to matters coming out, and some of them were embarrassing. We had a couple of cases, one in the disability area, one in the First Nations area, which were very uncomfortable for the institution. We worked them through over time. They sometimes got us down, but we came through the other side. But I don't think we spent a lot of time seeking to defend the barricades, even though we always had a legal bill.
Sure. I need to get your opinion on the whistleblower protection idea first up, because it is another agency that we have to set up, because, as we all acknowledged on this webinar, that the leadership for transparency should come at the top, and we shouldn't have to have whistleblowers courageously putting their lives and livelihoods on the line.
I guess I generally have a distaste about setting up more agencies. I mean, at the state level in Queensland, we have an Integrity Commissioner, that's an Officer of Parliament. We have an Information Commissioner, that's an Officer of Parliament. We have an Auditor General, who's now an Officer of Parliament. We have a Crime Commission, CCC, which obviously reports to Parliament as well. I would naively perhaps hope that you can do things to encourage trust amongst the integrity bodies so that they themselves aren't being rivalrous. Because I do know from a punter's perspective, as it were, that the whole collection of agencies is quite mesmerising. And the term navigability was used before. I think that's right. People have got to know where to go, because for most people, the matter will start off as a complaint, or it might start off as a matter of corruption, but oftentimes as a matter of complaint. The most resistance I got to any of the recommendations that I made in my report was the idea that there should be a clearinghouse for complaints in the public sector. And finally, the then Premier said that the government wouldn't go ahead with implementing that recommendation because it would cost too much. Within 24 hours, she changed her mind and said, no, they would go ahead after all. But it all went to the point of the system being understandable from the perspective of members of the community. Yet in Brisbane, which is a city with one local government area covering the expanse of the metropolitan, the whole metropolitan area, they've had a clearinghouse for complaints against services, not so much against people, for 20 years, and it hasn't been radical. So I am a bit concerned about having yet another body. I'm much more interested in trying to get the roles amongst those bodies sorted and well understood, and then not to be a rivalrous relationship amongst some of the integrity bodies, which undoubtedly there has been. The integrity body that's lost out most in Queensland over the years has probably been the Ombudsman, which is supposed to be the people's protector. It was the second integrity body established in Queensland in 1974 or whenever, 100 years after the Auditor General. But now we have a range of ombuds people, for different industry sectors as well as the overall, and the original role has been almost lost.
That's a good point, Rex, isn't it? The Commonwealth's got an ombudsman. Why isn't the ombudsman protecting whistleblowers and public interest disclosure people who come to him or her?
Well, that's an interesting question. In actual fact, there's a pathway under our current whistleblower laws where if you blow the whistle and you're dissatisfied with the outcome, you can actually appeal to the Ombudsman. Now, the interesting thing is in Richard Ball's case, he was dissatisfied and rightly dissatisfied with what the ATO did, but he then thought, I'll go to the Inspector General of Taxation, who didn't have powers to look at whistleblowers, but clearly was an expert in tax. And so he never exercised that right to go to the Ombudsman. Again, had we had a whistleblower protection authority, they could have counselled him on the correct pathway to go. I will just add a piece here because I think it's absolutely worth saying. We do have broken whistleblower laws. Actually, the government has conceded that. We don't have a whistleblower protection authority, so it leaves everyone in a really awful position. But in 1901, the Parliament gave the Attorney General, who is responsible for Commonwealth prosecutions, responsible to the Parliament for those prosecutions, gave him an exclusive power to use without any bars that say, there has to be exceptional circumstances, just that, of course, they're accountable to Parliament, gave the Attorney General the ability to drop a prosecution. And in a circumstance like Richard Ball's, where he's blown the whistle, all of the charges that relate to that he's been, all of the charges or the allegations made relate to things associated with that blowing of the whistle, and none of them relate to disclosing information publicly. In those circumstances where he blew the whistle, in a proper manner. There was a botched investigation. He then ended up going to the wrong agency, but after the ABC's Mongrel Bastards show on Four Corners, the minister then caused the Inspector General of Taxation to actually do an investigation that vindicated Richard Ball's position, and a whole bunch of changes were made in the way in which the ATO use their powers to collect tax arrears. Now, there is no question that what he did was in the public interest. There's no question that he's now in a court because of broken laws, and yet Mark Dreyfus, our Attorney General, has not found the courage to simply drop that prosecution in the public interest. And while he doesn't, two things are occurring. Richard Boyle and his family are suffering immeasurably, and as Catherine pointed out, no one in their right mind in this country would blow the whistle, because it just isn't worth it. And so his failure to exercise a power that was given to him by the Parliament is in actual fact, from a public policy perspective, is causing great harm, because there are no sort of policemen inside organisations spotting corruption and doing something about it.
No, good points. A very distressing case for all concerned, and I'm sure the Attorney General is very well aware of that. It's a question now of the role of the upper houses. I've been in New South Wales for 34 years now, and I support the proportional representation system, which has given us many voices in upper houses. And Rex, you've found that to me a major benefit. Tell us, Catherine and Maria, about the allies for transparency that exists right through the representative parliaments of Australia. And because, do you agree that integrity and transparency are still on the agenda? Up high with climate change. I know we're all swamped now in cost of living as a political issue for coming up to the next election, but what role, what possible agenda can we set for transparency up to the 25 election?
Thanks,
Catherine.
Quentin. Thank you for that. So I guess to start off with, I'd say we would like to see transparency and accountability remain issues that factor heavily into people's thinking when they're thinking about who they're going to vote for. And I don't see them as separate from cost of living issues. They are fundamentally related to cost of living issues, because when we see decisions, like I'm a Victorian, when we see decisions like suburban rail loop, the sort of spending that's gone on in Victoria without proper accountability, the impact that has on the budget for Victorians, that's an integrity issue. And we need to conceptualise those things as such. They're not entirely separate. And we need to bear in mind that when financial decisions are made by Parliament, say in respect of grants programs, currently the situation around the country really is that there is not sufficient oversight of the way in which grants monies are distributed. Can we be confident that when our taxpayer funds are being distributed, they're going to where they are most needed? I would say no, we cannot be confident about that at this stage, which of course is not a cost of living issue as such, but it relates to the question of whether members of our community have what they need to thrive. So I would say, first of all, the two things for me are not totally separate things. And secondly, I would say that unfortunately, it does seem to be the case that the two major political forces both see that they have an interest in there being less transparency and less accountability, because they know that sooner or later they're going to swap. One of them's going to be in government and it'll switch, and the party coming into government currently in opposition might like transparency in opposition, but it's not going to like it in government, which is why we have such difficulty progressing these reforms, and why the power of the crossbenchers around the country has been fundamentally important in trying to shift that situation.
Peter, is that a good point? Is that a good point?
Have a go at Queensland for not having an upper house.
I am having a go. Unicameralism is easily, much more easily corruptible. I hasten to regret to say that the use of parliamentary privilege and the disclosure of documents, I mean, it's gone all the way up to High Court with Brett Walker, SC, helping the New South Wales Upper House get its its rights under the Constitution established that if the upper houses call for papers, they must be delivered. Rex, that's your experience. That's why you want to get back in the Senate, isn't it?
Well, this goes to some points that Catherine were making. It's a very well established fact that you can't be a judge in your own cause. And so when in a courtroom, when a court subpoenas a document, of course, the executive can front up and say, there's a public interest immunity as to why these documents should not be surrendered to the court or used in open proceedings. But it is for the court to decide whether or not they'll accept the claim. Now, it turns out that's exactly the situation that occurs in the Senate. The Senate can make an order for production. The executive have the right to stand up and say that they object on public interest immunity grounds to the disclosure or the tabling of documents. But ultimately, under the law, it is for the Senate to decide. And so whilst there's a whole bunch of things going on and mechanisms in place, and I've done this in the past, you simply put a motion to the Senate saying we don't accept the immunity, and that then gives you options to kick ministers out, to strip them of some of their powers, or indeed refer the matter to the Privileges Committee. But unfortunately, senators are their own worst enemy. They'll stick with party lines, particularly the duopoly will stick together, because even the opposition will say, geez, I don't want to go that far to enforce the powers of the Senate, because what happens if I want to keep something from the Senate in the next Parliament? But so in some sense, the problem, orders for production of documents is accepted in law. There's a High Court case called Egan and Willis that absolutely affirms the right of an upper house, in fact, either house, to have access to information to allow it to do its oversight a job or to properly consider legislation. There's no question about that. The Senate could enforce it, but unfortunately, the Senate is weak, and that's a function of the senators that are inside the chamber. And I'll just...
It's always the way. It's down to the individual. We've had a great session. Look, quick final summation. Maria, how do we keep transparency in the political agenda when everybody's worried about the cost of living, even though Catherine's made a very good point that transparency is part of the cost of living?
Look, I think we need to recognise that we're very lucky to be in Australia when we're looking at what's happening overseas in the US and elsewhere. And to prevent that sort of backslide, we do need our parliamentarians to look at the importance of transparency, to go back to bipartisanship and look at the objects of the FOI Act and other acts that are meant to strengthen our representative democracy. And we really need an acceptance of scrutiny as part of the important role that the citizens get to play in assessing who do we vote for next election. Are we going to vote for parties who continually hide what's going on and evade scrutiny? Or do we expect disclosure, and do we expect to be fully informed in decisions that are being made in our name and fulfilling our right to know? And I do think there's both an education piece for the Australian electorate that needs to be done, but also we do need to see some leadership in politicians as well. So we're hoping that Rex has a broader effect on others in the Parliament too.
Peter Coaldrake, how do we keep transparency on the agenda?
I think the link has already been drawn between cost of living and accountability. People don't want to be ripped off. They want governments at a state level. Oftentimes it'll be the explosion of costs of big capital works programs. Those activities will, and if there is over expenditure and waste of money, that will get through to people. So that people will link that to their hip pockets. So I think there is a direct link between how people feel government is dealing with them and accountability and cost of living. We're in no man's land or no person's land if people think of integrity and accountability over here and cost of living over here. They're enmeshed.
Wonderful summation, everybody. Thanks very much for your contributions, and grateful thanks to the Centre for Public Integrity for maintaining the momentum for integrity in our mighty nation. Thanks a lot. See you next time.